Well, welcome everybody. We are about to make a fairly substantial shift in the structure of the syllabus today. We're moving from the sort of introductory part, which was mostly about sort of history, critique, theory behind international criminal law, and now to the second part, which is more about doctrine. And we have a number of lectures about doctrine in international criminal justice before we finally move in to discuss institutions. Of course, to some extent, we have been discussing institutions throughout, but the emphasis in the third part will be squarely on them. So, today what we're going to discuss initially is a principle of non-retroactivity of criminal law. And to some extent, I think we've mentioned it in passing at different junctures. It has been really a major concept in the history of international criminal justice and has important implications for our understanding. Let me talk to you initially about what I hope to go through with you over the course of the coming hour to set the stage for a discussion that we can have after that point. But as a point of entry into thinking about the doctrine of international criminal law, I think the principle of non-retroactivity is especially helpful because it sort of trains our focus on thinking about where this law comes from, what its source is, and the extent to which we can circumscribe its scope vis-a-vis the sort of political forces that we have been discussing throughout. So here are some of the things that I want to go through with you. Firstly, I want you to emerge from this lecture and our discussion after it with an understanding of why the principle of non-retroactivity is important. What are the values or the issues that are at stake with the principle of non-retroactivity? And how do those map onto international criminal justice in particular? And that second part is really emphasized here in number 2. It's important that you have an appreciation of the tensions with non-retroactivity in international criminal law in particular. And this is important both historically and in modern times. So I want you to be able to trace a little bit the history of this particular concept and to observe a rhetorical shift in more modern iterations of international criminal law, but nonetheless to perceive ongoing struggles with the concept and the ways in which it is likely to play out. And finally, what I hope you come to understand through the course of this lecture and our discussion afterwards is essentially an ability to see the issues in action with respect to war crimes in non-international armed conflict and recruitment of child soldiers. In truth, there are quite a number of different areas that we could discuss, some of which I've worked on, and I suspect I will flesh out over the course of our discussions together. But I've chosen these two, the reception of war crimes in non-international armed conflicts at the International Criminal Tribunal for the former Yugoslavia, and then the recruitment of child soldiers at the Special Court for Sierra Leone as sort of emblematic of different features that have played out in the field right the way throughout its history. So I'm looking forward to discussing those with you also. And finally, again, I want to emphasize the importance of you sort of cross-referencing and building intersections and correlations between the different aspects of our classes together. This becomes especially important now that we move into doctrine, because I hope that I've really laid a foundation that gives you something of an orientation in the history and in the theory, which will be useful to you as you come to think about concepts like non-retroactivity and the various other elements of international criminal law doctrine that we'll discuss together. So again, the onion factor, trying to sort of build more and more knowledge in an exponential way because of the way what we learn in each of the classes sort of cross-references and builds off information that we've been and ideas that we've been discussing in previous lectures. So that's really the overview of what I'm hoping you acquire and how this particular lecture and discussion is useful to you. So what is the concern with retroactive criminal law? How important is this concern? And one of the reasons that I wanted to give you the Sam Hingan-Norman decision from the Special Court of Sierra Leone, and particularly Justice Robertson's dissent in that opinion, is because it contains a very strong articulation of what the concern is with retroactive criminal law. I think stronger than elsewhere in the history of international criminal justice. And I want, I guess, to start answering the question by referencing that stronger view, and then give you another answer which tries to play it down. And I'm hoping that between those two answers you sort of come to have reflections on the role of this particular concept in international criminal justice. So the stronger articulation of what the concern is, an articulation which suggests that it's exceptionally important, goes a little bit like this. You know, the idea of retroactive criminal law is really an affront to freedom. It's an affront to freedom because it's retroactively criminalizing something that was innocent at the time the actions took place. And this is an affront to freedom because people at the time, in any given context, don't have the ability to comport their conduct with the strictures of law. They are one never knows really whether what one's doing is going to be subject to criminal law sanction in the future that is retroactive in effect, and so it is tyrannical. It is no coincidence that many international crimes, and I referenced this earlier, employ the law and the legal system to bring themselves about. And I invited you to watch the fantastic movie Judgment at Nuremberg, which is about putting the legal system in Nazi Germany on trial. What an amazing case in international criminal justice, the justice case at Nuremberg. An amazing phenomenon, an amazingly audacious idea that you would put the judges, the prosecutors on trial. And part of what was problematic about the function of German criminal law in the service of Nazi violence was that criminal law was employed retroactively. Offenses were made criminal by the fact that they were passed by legislation with retroactive effect. They were also passed in an amorphous way. Instead of like precise stipulation of what the parameters of a criminal offense would be, there was legislated a notion that anything was an offense that was a crime against the German people, and judges thereby had a very broad notion of what could be criminalized that was essentially deferred to them. So Justice Robertson's position at the Special Court for Sierra Leone is, we're not just discussing little trivialities here. What we're discussing is a principle that's at the heart of a liberal conception of governance. And what's at issue here is whether international criminal law will emulate the same sorts of authoritarian methods that those it's prosecuting have adopted. Do you see the dilemma? The question is, well, we're better than that, right? Like, we're more principled than what took place. We're not going to harness criminal law in the ways that the people we are trying to hold accountable did. We are going to be more principled, and we are going to stick to principles about criminal law being prospective in orientation, precisely because one of the functions of this whole project is to preserve freedom and to insulate societies against the rise of authoritarian governments that produce the sorts of crimes against humanity, genocides, and so on and so forth, that this area preoccupies itself with. So the strong version of what's the concern is we're very concerned about it because it's at the heart of a liberal or libertarian project. It's a mechanism for guarding against descents into authoritarianism and the harnessing of law enforcement in service of that idea. How important is it? It's crucially important. We know from history that it is crucially important as a principle, and symbolically for international criminal justice, it is also crucially important because we do not want to emulate that which we are judging. And so that's the strong version. Shall I give you the weaker version? The weaker version is, listen, let's not be too cute about this stuff. What we're discussing is people like Mengele performing the most spectacularly brutal experiments on human beings you can imagine. In fact, they are more brutal than you can imagine, which is partly what makes them so unbelievably terrifying and so revealing of a human choice that went into constructing this brutality. And because they're so revealing of a human choice, it would be absurd not to punish the individual for making that choice, for employing his or her considerable creative talents into bringing about an atrocity of this spectacular violence. So don't come to me in the wake of violence this intense. Don't come to me with these like legal concepts that, apply in the normal course of events, that apply in societies like yours or mine outside where people aren't being rounded up in the millions and executed, deported, experimented upon, etc. It's not about that. This is an exceptional circumstance. And in an exceptional circumstance, the sheer moral gravity of what's at issue here overrides these ideas about retroactive criminal law. It's so bad. You just have to find the law. And if you have to create it, then create it. But don't be so legally formalistic to think that, we can just let these people go because of some technical legal argument and some, broad principle. Where does the principle come from anyway? If it's just a principle, is it even law? Listen, let's brush this under the carpet. Ideally, it would be good to observe it, but if we can't, no big deal. So I'm hoping that in those two arguments, you start to get a sense of some of the issues that are at stake here. So question 2 is, what's the Latin phrase that's frequently used to reference this principle? Well, there are two in particular, but I want to introduce a third concept that I think arises from my first explanation just a moment ago. The first phrase is nullum crimen sine lege, and that just means no crime without law. I can write it up here. So it's nullum crimen sine lege. The other one that's related is nullum quona sine lege. The third I want to discuss is strict interpretation. There is a Latin phrase that escapes me momentarily for the idea of strict interpretations that that are interpreted in favor of the accused, but I will look it up before we have our conversation and add it to the meaning. The essence of the idea is strict interpretation. So, nullum crimen sine lege just means no crime without law. Nullum poena sine lege means no punishment without law. So even if something is criminalized, the scope of the punishment needs to be defined by law. It's not just like, oh, well, you're guilty based on a criminal offense, and now I sentence you to blah, whatever I want. Penalties need to be circumscribed by law also. And it's really important that crimes are defined in such a way that they are to be strictly interpreted in favor of the accused. It's not sufficient there as a crime of, I don't know, being a bad person. Anyone who is bad is convicted of an international crime. Well, bad is too subjective. It's too open-ended. It gives too much interpretive power to courts and insufficient ability for citizens to comport themselves in accordance with the law. So those are a series of terms that you will hear a lot in international criminal justice. I'm mentioning them here mostly for your information so that you know when they're referenced that they're sort of making a direct allusion to this idea of non-retroactive criminal law. The idea is all law should be prospective and strictly defined if you are going to punish people with it. Otherwise, it risks facilitating authoritarianism. You with me? So, now we get into the history a little bit. And my question here is, what did judges at Nuremberg say about the principle of retroactivity? Do you agree? But actually here I'm emulating one of my pet criticisms of the way people think about international criminal law. And that criticism is that everything started with Nuremberg. So if I'm going to ask a question about retroactivity, I should start at Nuremberg. But actually the history of legality started, or concerns about legality started well before that, in discussions about trying Wilhelm II after the First World War. And I think I referenced this in our previous discussions about history, but ultimately, this problem with non-retroactive law led the United States to argue against and not support an international tribunal to try Wilhelm for international crimes. And so he was exiled to Netherlands and lived out a life complaining about the palace that he was assigned to in the Netherlands, etc. And so let's dwell on this just for a moment, because the problem refigures and represents itself in international criminal law all the way through this history, all the way up into the International Criminal Court, although it gradually diminishes in significance over the course of that history. So the problem is, and this problem is intimately linked with the history of international criminal law and how it emerges in public international law. The problem is, people say, well, you know, it's pretty atrocious what these people are alleged to have carried out, but there's no law to prohibit it. And if there's no law to prohibit it, it's not a crime. And you're doing something inherently authoritarian by constructing one. Now, in the previous discussions, I talked to you about how after World War I, there was sort of attempts at accountability that proved ineffective and probably counterproductive. And then how after the Second World War, there was a sort of a strong reaction about the failed experiments of the First World War and an inverse position taken by exactly the same actors, in fact, exactly the same people, after the Second World War. And this was precisely true on the principle of non-retroactivity, because the US government had said, listen, we'd be inventing the law if we created an international criminal tribunal, because there's just no precedence for using violations of international law as crimes. What would you use? And then after the Second World War, the US government was, but not much has changed in terms of the creation of international crimes or institutions, but yeah, it was so bad. Terrible. Can't let this happen again. Let's create a tribunal. And the defendants, the first thing they say is, hey, there are no international crimes you can try us with. There are none. And let me situate that a little bit for you for a moment in the context of the four grounds for jurisdiction that there were at Nuremberg. The four types of crimes, and we'll discuss all of them later on in the course. The four crimes are war crimes, crimes against humanity, genocide, and aggression. A very brief overview of the four, and we'll go into far more depth later. War crimes require war, and they are derivative of what some people call international humanitarian law, other people call law of armed conflict. Sort of the Geneva Conventions are an important aspect of that law. But importantly, none of the treaties, and there were many treaties that governed international humanitarian law, the law of armed conflict. There were many treaties previously, but none of them made violations of those treaties subject to individual criminal responsibility. And let me say a little bit about that because it's significant to your understanding. So all of these previous treaties, there was a Hague Regulations of 1899, there were Hague Regulations of 1907, there was a Geneva Convention of 1926, if I'm not mistaken. All of these were treaties, and as treaties, they were state-to-state obligations. So there were obligations like a contract between governments, between states. And up until that point, I think I showed you this in a diagram in one of our first lectures. Up until that point, public international law was uniquely about government-to-government relations. And so there was no mention in any of these treaties about prosecuting individuals, let alone the idea that an international criminal court could take on that role even if there was responsibility for war crimes. So what was monumentally significant about the Nuremberg approach to war crimes is just took these treaties and said, you know what? International crimes are committed by men, not abstract entities, and if we find some individual having violated one of these propositions, it gives rise to, we're going to criminally prosecute people for it. This gasp. But that's never been done. But the treaties don't say you can do that at all. They're all about state-to-state relations, and actually no aspect of international law allows you to do that. It's always been about state-to-state relations, and so you're just going to reach in and start constructing individual criminal responsibility. Wow. So in other words, what Nuremberg does to war crimes is it just builds this full apparatus of criminal law around a public international law treaty when that apparatus of criminal law did not exist previously. It's like, oh, wow, that's amazing. And so there's a deep concern that this violates principles of non-retroactivity. In actual fact, war crimes is a little bit more complicated because, as you remember, the Lieber Code in 1868 had war crimes. There had been a concept of war crimes that existed in different ways, shapes, and forms prior to Nuremberg, but the Nuremberg Tribunal doesn't make any effort really to justify its conclusion that there are war crimes in reference to any of this previous practice. It's just like, well, war crimes are criminal. We're going to prosecute them as such. I have to pause here to introduce a concept in public international law. There's going to be a question about it momentarily. I think maybe I'm going to answer question 3 directly. and then substantiate it. So the answer to question 3 is that the Nuremberg Tribunal says, you know what? The idea of non-retroactivity is just a principle of justice, to be weighed with other principles of justice. One sentence. And it would be an affront to principles of justice to let these individuals go because of a potential violation of the idea of non-retroactivity of criminal law. Voila! It's a principle to be weighed against others. And in a way, in my view, that was at least an honest answer. And we'll see momentarily that later forms of international criminal law attempted to take the high ground on non-applicability, on non-retroactivity of criminal offenses, and say, oh no, we've changed now, we really adhere to it in a strict way, but they smuggled in interpretations that really are hard to justify relative to the principle, sub rosa, without sort of being fully frank about what was taking place. So that's an answer to question 3. And I want to move on because my subsequent questions ask about sources. And so it's important for you to understand sources before I come back to discuss the other 3 or 4 crimes that we've identified at Nuremberg. So war crimes were particular in a way because the sources for drawing on war crimes were treaty-based. And I referenced the treaties that had given rise to an important body of international humanitarian law prior to World War II. And so all the Nuremberg Tribunal had to do was sort of like construct a criminal law framework around public international law treaties, which essentially contracts between states. The contracts themselves didn't anticipate it, but like that was the creative work of Nuremberg, and there was some precedent, but a little vague. And so treaties was really the primary source, and then there was this appendage of criminal law around it. But in other realms, the history of international criminal law is based in customary international law, not treaty. And if you haven't studied public international law before, I suggest maybe you spend a little bit of time looking into what the elements of customary international law are. I won't say especially much about it, but there are essentially 2 components. One is a use, so it's state practice on the one hand, that's the first element, and the second element is combined with a sense of obligation to be carrying out that stated practice. So one way to think of it is sort of like a non-written common law, which evolves through practice and a sense of obligation based on customs from a wide variety of states that are interested in the issue. And the argument for the longest time, all the way up until the ICC statute, is that customary international law serves as a basis for most international crimes, including crimes against humanity. So prior to the Nuremberg Tribunal, crimes against humanity had been gestured at in a couple of treaties. One, the Treaty of Svev, that referenced the Armenian genocide and talked about crimes against humanity. Humanity was sort of referenced in different documents here, there, and everywhere, but there'd never been a treaty. There still isn't a treaty on crimes against humanity. There were no cases of people being tried for crimes against humanity prior to the Second World War. And so what was really significant about Nuremberg is that it gave birth to this concept of crimes against humanity precisely because there was a sense that there's just no way we can let what Germany did to its own citizens within its own sphere of sovereignty. There's just no way we can let that go. It's so transgressive. War crimes don't cover it because war crimes are about state-to-state interactions. And so, whereas war crimes had some sort of treaty, a basis in treaty, crimes against humanity had even less substantive history behind them at the time of Nuremberg. And Nuremberg's sort of creative agency around crimes against humanity is more intense vis-a-vis crimes against humanity than it is with war crimes. And really at Nuremberg, genocide emerges out of crimes against humanity as a subspecies of crimes against humanity. The term isn't much used at Nuremberg, and it doesn't feature in the Nuremberg or Tokyo charters as such, but it's a term that's sort of constructed by a scholar called Ralph Lemkin around that period and culminates in the Genocide Convention of 1950, which is a year or two after the Nuremberg judgment. So the final area of criminal offending that is formally included within the Nuremberg Charter and Tokyo Charters is the crime of aggression. And aggression just means going to war illegally. So it's starting an illegal war. What's fascinating about the history of aggression is that there had been an attempt to make going to war illegal that was sort of codified in the Kellogg-Briand Pact. But again, like war crimes, absolutely no reference to this being a criminal offense, let alone a criminal offense that gave rise to individual criminal responsibility, let alone an offense that gives rise to international criminal responsibility that an international court could enforce. So all of those extra inferential steps are steps made by the Nuremberg Tribunal itself. And what results is a process that leaves several people fairly aghast. This is Victor's justice. The victor waltzes in, prosecutes half of the offending, or 3/4 of the offending, or prosecutes the other side's offending, and it constructs an enormous amount of law, pulls it out of thin air for the purpose, and says, well, in a single sentence, yeah, this non-retroactivity of criminal law is an important principle, but it's a principle to be weighed against other principles. And in the circumstances, it would be such an affront to justice to let the men who orchestrated this violence walk free that we'll tolerate the sort of violation of non-retroactivity in criminal law. So interesting, right? That is the inherited position from Nuremberg. It at least has the good measure of candor, of honesty about what it's doing, and then it must be controversial, or at least subject to debate about whether that sort of legal creativity is justifiable. And that really is the work that was necessary to overcome the hesitations that American statesmen and diplomats had after the First World War. It's like, wow, there's just no law there. After the World War II, they sort of filled in the gaps and made peace with that. The question is, well, how tenuous was this as a basis for international criminal law at Nuremberg? I mean, I don't want to prejudge it, but I suspect I should probably offer my view. Pretty tenuous. Pretty tenuous. And certainly if I were one of the people prosecuted at Nuremberg, I would think it was a complete affront. There are other aspects too, not just the crimes, but like forms of participation and defenses and all of this criminal law doctrine that's necessary to bring these charges is smuggled in effectively by predominantly American lawyers as a basis for judging defendants at Nuremberg and Tokyo. But then the allegation is, well, but you're using American law to prosecute us, and that's not international law. How does this work? So it's a stumbling block and a difficult issue. I wanted to talk to you briefly before I give you some examples from modern ad hoc tribunals and then speak to you about the International Criminal Court. I wanted to give you a brief statement from the European Court of Human Rights, because the European Court of Human Rights has had occasion to think about these issues a number of times. And the European Court of Human Rights view is, well, firstly, I mean, what's amazing if you look at the European Convention on Human Rights is it has the prohibition on non-retroactive criminal law. And it's like, well, this criminal law must be prospective. It's a violation of human rights to create retroactive criminal law. And then immediately underneath it, well, the only exception to this is if the person being tried is a Nazi. And so this idea, it's sort of this interesting historical relic, which I think some people would blush at now, because we didn't want to be doing some of the sorts of things that the Nazis had done themselves. It's pretty unprincipled and pretty dangerous. Nonetheless, there it is. The European Court of Human Rights has found that as long as the criminalization is foreseeable, quote unquote, that there's no violation of the proposition of nullum crimen sine lege, the idea of retroactive law or punishment. That seems pretty, that seems like a fairly permissive standard to my reading. What it means is, if something's really terribly awful, it's foreseeable that it's criminalized, and regardless of whether it is or not, it's sufficient that it was foreseeable. It seems a fairly amorphous standard, and isn't among those who think actually it should be far, far stronger than that, because what's at issue is the rise of authoritarianism and the use of criminal law in service of that sort of undemocratic system of governance. But really, I wanted to talk to you about how this norm changed in ad hoc tribunals and hybrid courts in the first instance, and then in the second instance, how it's sort of changed again before the International Criminal Law for structural issues, and yet will continue to raise its head in interesting sorts of ways. And as you'll see from question 7, the answer to that question, to these questions in ad hoc tribunals in the 1990s, very much involves a schism, a break between the rhetoric around non-retroactivity of criminal law and the practice, which, in my view, retains some of the hallmarks of the Nuremberg reasoning. So I have 2 examples that I want to talk to you about and tell you stories about that illustrate this at ad hoc tribunals and at the Special Court for Sierra Leone, which I think are helpful in illustrating some of the moral problems that are involved in international criminal law, including in non-retroactivity of crimes. So these 2 illustrations are as follows. The first is about war crimes and non-international armed conflicts. And this is how this story goes. So, as you know, war crimes come from international humanitarian law, which is the Geneva Conventions. And the Geneva Conventions almost invariably, with one exception, which I'll speak to in a moment, the long history of international humanitarian law is about state-to-state conflict, which is described within these conventions as international armed conflict. So wars between governments, it's like Britain and Germany, that's an international armed conflict. It is state-to-state. And throughout this history, there had been no reference to criminal law violations in any of these treaties until the Geneva Conventions of 1949, and what these Geneva Conventions do is they say, well, of these 660 provisions in these 4 Geneva Conventions, a small, hardcore, serious violations we will call grave breaches, and we'll sort of like list them and do nothing more and say, oh, these involve individual criminal responsibility, and if any of your soldiers commit these acts, then you need to punish them for it, states. But none of those concepts of grave breaches of grave breaches of the Geneva Conventions apply in civil wars, what in the parlance of international humanitarian law is non-international armed conflicts. There is one provision in the Geneva Conventions in 1949 that applies to non-international armed conflicts, and that is something called Common Article 3. It is one provision out of 660. It is at least common to the 4, but such was the reticence to sort of enter into the regulation of civil wars that the vast majority of the Geneva Conventions of 1949 maintained this state-centric focus and created rules that apply uniquely to international armed conflict out of the expectation that, well, in a civil war, it's a matter for the government to use national law to do whatever it wants. It's a question of sovereignty, and we're not going to intervene in the state's sovereignty using international law to tell them what to do in those sorts of circumstances. The only exception, and it was a huge milestone when Common Article 3 was promulgated in the Geneva Conventions, is this one provision called Common Article 3, and it's like 5 or 6 parts to it, and they're all like about as fundamental as you can imagine, like no torture and no summary executions, and that's it. C'est tout. And importantly, nothing in Common Article 3 said anything about individual criminal responsibility. Not a word. Nothing in Common Article 3 said, or in the conventions themselves, said anything about violations being war crimes. Didn't mention criminal law at all in any meaningful way. Now, in 1977, there were additional protocols appended to the Geneva Conventions. So new treaties. A protocol is just another word for a treaty. Additional Protocol 1 applies in international armed conflict and therefore is interesting for this story. Additional Protocol 2 applies and augments to non-international armed conflicts and augments the protections already contained in Common Article 3. It adds 27 new provisions, still not many relative to the sea of provisions that apply to international armed conflicts, but still a degree of augmentation because many, many conflicts are civil wars at that time. But again, Additional Protocol 2 makes absolutely no mention of criminal responsibility, individual criminal responsibility, war crimes, grave breaches, or anything like that. So it's totally silent. Now, fast forward to 1993, the dissolution of the former Yugoslavia, which involved this really complex set of conflicts of wars between states that were newly recognized states that were formerly part of the former Yugoslavia, including Bosnia-Herzegovina, Serbia, Slovenia, etc., Croatia, and non-state groups that are fighting within them. And so the conflicts were super complicated because they involve both civil wars and international armed conflicts, often pretty tricky to figure out which was which. And around that same time, the International Committee of the Red Cross, which has a sort of a constitutional role as a guardian, a bastion of international humanitarian law. One of the leading academics in the world at the time in this area, someone called Theodore Moron, who later became president of the International Criminal Tribunal for the former Yugoslavia, and a commission of inquiry that acted as a precursor for the establishment of the Yugoslav Tribunal. All of them say, well, there's no war crimes in non-international armed conflicts. And in a technical, formal sense, they're right. They're right because there's absolutely nothing anywhere in international humanitarian law that would support that. And they're almost I want to say there are no cases, but there may have been one or two cases of individuals, I think none actually. There are no cases for individuals in being prosecuted for war crimes in non-international armed conflicts. So it looks like on paper, even if you're trying to make arguments from customary international law, you need virtually uniform state practice combined with an obligation to carry out that practice. State practice can be a range of things, from signing a treaty to carrying out a trial to sort of like making a public statement. But you got to wheel in something to show me that there's virtually uniform state practice among states to substantiate the idea that this is customary international law, absent a treaty provision which says violations of humanitarian law applicable in non-international armed conflicts are war crimes. Let me say that again one more time very briefly, because it's important you sort of understand this. There were explicit provisions in international humanitarian law that made for war crimes in international armed conflicts, but that they had no equivalence in the body of law of international humanitarian law that applied to non-international armed conflicts. And so all of these experts say, well, there's no war crimes in non-international armed conflicts. But herein comes a dilemma. And the dilemma is very acute, and in a way, it sort of highlights how some of the agonizingly difficult decisions that have to take place within this field. And so in the first judgment, a low-level individual, camp guard called Dusko Tadic. Tadic is tried for war crimes, including torture. Low level in the sense that he's not a political military leader, but nonetheless is alleged to have committed some heinous crimes in a detention facility. And the case goes to trial, and he hears the witnesses, and you can imagine, you're in trial, and there's a gallery of all of the families of victims, and they're like, finally, there's going to be some accountability for what took place for our family members. Understandably entirely traumatized by an horrific set of events, and they're in the gallery, and then suddenly this issue in public international law arises in the trial. And it arises in the trial because through a complex process of proving what type of conflict took place, the trial chamber reaches the conclusion which actually, these crimes took place in the context of a non-international armed conflict, i.e. a civil war. It's between a non-state group and a government, and that makes it a civil war. So the defense says, there's no war crimes in non-international armed conflicts. And place yourself now behind the bench. Here's your choice. And this choice, it makes it real. On the one hand, you look at this and you go, technically that's right. Technically, there's a real paucity of state practice and not anywhere near close enough to constitute customary international law. Technically, that's right, and all of these experts saying that's the case. All right, so technically there's not a war crime, and yet remembering Nuremberg and looking at the facts, and the gallery's packed with family members, and the allegation is that this individual tortured a number of people to death. So, you're going to let this guy go, the first case in the first instance of international criminal law at an international level since Tokyo Tribunal. You're going to say, sorry guys, technically in public international law, there's this distinction between international armed conflicts and non-international armed conflicts, and one has war crimes, the other doesn't. So in reality, I'm sorry I have to let you go, because although what is alleged against you is crazy reprehensible, there's this one technical issue about retroactive criminal law, and there's the door, so sorry. Tricky decision. It's a decision between formalism, like legal formalism, and substantive justice. And what's significant about this is that the Yugoslav Tribunal says, we're not like Nuremberg. the prohibition on retroactive criminal law has crystallized as a formal commitment. It's not just a principle to be weighed against other principles. That's ridiculous. It's a core principle. And yet, nonetheless, it was able to find that there was criminal liability in non-international armed conflicts. So there's a concern that ultimately the rhetoric changed, but the analytical method did not. Nonetheless, what's really interesting about the idea of war crimes and non-international armed conflicts is as soon as a court leads this process, states endorse it wholeheartedly. So all of these states start adopting in their national legislation war crimes that are applicable in non-international armed conflicts. And then when states come together to negotiate the Rome Statute for the International Criminal Court in 1998, they insert a whole big new list of war crimes and non-international armed conflicts that vastly exceeds Common Article 3 and others. So whereas formally it may have been an extension at the time that the Tadic decision was made, states fully ran with it and ratified, in a sort of a non-technical sense, and ratified the decision and incorporated it into international criminal justice. So it's an interesting moment that sort of tests our commitment to non-retroactive criminal law in important ways. So that's one example. The next is recruitment of child soldiers at the Special Court for Sierra Leone. And I'm going to leave you, I think, to read that closely. That also is an attempt to ascertain the meaning of non-retroactivity in international criminal law. It's an attempt to figure out whether the prohibition on use and recruitment of child soldiers was a criminal offense at the time that these cases took place. And it's an attempt to bring together statements by the Secretary General of the United Nations, of treaty negotiations, all of these different forms of state practice to establish that as a matter of customary international law, these propositions were criminalized in public international law at the time of the offenses. They raise interesting questions, though, like, if all of this gymnastics is necessary to ascertain the meaning of customary international law at the time, is it reasonable to expect that military leaders in Cambodia or in Africa and elsewhere will be able to comport themselves with this? Have we really departed so significantly from the Nuremberg principle that non-retroactivity is a principle to be weighed with others when we rely so heavily on customary international law as a basis for defining these offenses? I guess my perspective on this is having worked as an appellate lawyer where customary international law is the basis for all sorts of criminal law doctrine like superior responsibility and things of this sort, you end up, in order to sort of ascertain the meaning of a particular criminal law doctrine, you have to end up taking these surveys of state practice around the world and try to sort of aggregate them into a unified common denominator that reflects the substance of the proposition, which, well, let's just say I wouldn't want to be tried on the basis of customary international law. It seems too amorphous. That is inconsistent in ways that are inconsistent with the idea of strict interpretation in a criminal trial. One of the reasons why the ICC, the Permanent International Court, emerged, though, was that it promised to create an institution that would cure this forever. These struggles that we'd had with non-retroactivity from the First World War, Second World War, the end of the Cold War, now we would have an international criminal court that was prospective in vantage and that was based on law that states had agreed to ahead of time. And here, then we would finally overcome this long-suffered fixation on non-retroactive application of criminal law. And yet we don't fully get out of jail that easily, because remember, the Security Council can refer Sudan and other countries to the International Criminal Court. And so in those instances, Sudan hasn't consented to a prospective jurisdiction moving forward, and there's still a question about whether Sudan is based on customary international law. Also, the ICC statute is in many respects inconsistent with customary international law. States defined international criminal law in stricter ways in most instances when they figured that they may be captured by the provisions. And so then there becomes this complex and interesting relationship between international criminal law as espoused in the ICC statute and this parallel customary international law governing international crimes, which has been used in ad hoc tribunals and special courts and hybrid institutions. All of this reflects the idea that I think I mentioned at the very beginning, that international criminal law isn't like a single monolithic universal concept. There's quite substantial variation from one incarnation of international criminal law to the next. So let me finish then by with my onion factor, that is the idea of circling back and asking questions about how this relates to other components of what we've been thinking about. And maybe what I think I'll do, given the interests of time, is I'll just ask these questions now and end this lecture, and then we can open it up and discuss more fully. But I'm hoping this particular lecture on the history and application of non-retroactivity of criminal law gives you an insight into some of the other discussions we've had, like how does all this affect our concept of what international criminal law is? And to some extent, I've sort of foreshadowed that just now. How does this relate to Maigrey's survey of criticisms of international criminal law? In a number of places he refers to sort of doctrinal ambiguity. How salient is that, and how meaningful are the struggles with non-retroactivity in that broader conceptual framework? And then similarly, the Gary Simpson lecture that we saw just a moment ago, how does retroactivity animate some of his ideas, and why would he be concerned about everything that we've just come through? So I'm going to end this lecture at 1 hour on the dot. So looking forward to having conversations about these three questions and any other material that this lecture's raised. Thanks.